So, now the plaintiff is suing the defendant, okay, to recover the car, okay, because the check given by X to pay for the sale of the car was dishonored, okay. So the Court of Appeal held that excuse me. Okay, so the Court of Appeal held that X, as the original buyer, was in the possession of the car with the consent of the plaintiffs. So he could pass a good title to Y, who in turn transferred it to the defendant. Okay, in other words, the defendant had a good title to the car that he had bought from Y and bought Y, who bought it from X. Okay, so here the plaintiffs, okay, would or have no claim against the defendant, but the plaintiff's remedy lies against X. Okay, so that would be the concept of Nemo dart and also the exceptions to it. Okay, right. So we will move to the subsequent part of sale of goods. Okay, where earlier on we have looked at the formation of a Sale of Goods Act and then the parties to it, and then we have also looked at the terms, okay, containing the conditions and warranties, and then we have also looked at the passing of property, passing of risk, okay, the perishing goods, and then we have also looked at the concept of Nemo dart, okay, and this part we are going to look at the performance, okay, the performance of the contract of sale, okay, and there are two basically or two fundamental obligations, that is to deliver the goods and to accept the goods, okay, and we will also look at the remedies at the later part. Okay, what happens if the buyer fails to take delivery? Okay, what if the buyer fails to accept goods or to pay for goods? Okay, what rights does an unpaid seller have against the goods? Okay, and what happens if the seller fails to deliver the goods, or what happens if there is a breach of warranty committed by the seller? Okay, so we are going to look at all this. Okay, so performance of the contract, as I said earlier, normally involves delivery of the goods and then acceptance of the goods as well as payment of the purchase price. So we will look at delivery first. Yeah. So generally, Section 31, okay, imposes a duty on the seller to deliver the goods, and it also imposes a duty on the buyer to accept the goods and pay for the goods. These duties are to be respectively performed by the buyer and the seller, okay, according to the terms of their contract of sale. And then Section 32, we have seen this earlier, provides for a general rule, okay, that is, the delivery of goods and the payment of purchase price shall be made concurrently. Okay, concurrently. That means delivery of goods and payment of purchase price shall happen at the same time or simultaneously. Anyhow, the buyer and the seller may agree that delivery and payment be made on different occasions or at different times. So in essence, it is up to the parties to agree whether they want to have the delivery first or they want to pay for the goods first. If there is no such agreement, then the general rule of concurrence shall apply. Okay? For example, when you go to Sing Heng, you go to Harvey Norman, or you go to whichever shop, okay, and this seller, okay, we use Harvey Norman as example, agrees to sell an air fryer on credit. So you as the buyer will bring home the air fryer first. Payment will be made at a later stage. So here, delivery happens before payment because Harvey Norman and you as the buyer, Harvey Norman as the seller, agree to that. Okay? So it goes against the general rule that payment and delivery shall happen at the same time. But this is not unlawful, or this is not wrong, because Section 32 itself has, as I said, has provided for the phrase unless otherwise agreed. It starts with the phrase unless otherwise agreed. So it is up to the parties to agree. So when you go to Harvey Norman to buy the air fryer on credit, that means delivery happens before payment. That is what has been agreed between you as the buyer and Harvey Norman as the seller. So it falls under the phrase of unless otherwise agreed in Section 32. Okay, this is just an example of what is happening in our daily lives. Okay, we are quite accustomed to it without thinking much when does delivery actually happen. Okay, so what really amounts to delivery in the eyes of law? Section 2 says delivery means voluntary transfer of possession from other person to another. Okay, so here again you can see the differences between possession and ownership of property in goods. Okay, delivery merely transfers the possession of the goods from the seller to the buyer. It does not involve transfer of ownership. That's why in my example earlier, when you as the buyer buy an air fryer from Harvey Norman on credit, I said delivery happens before payment. Okay, the possession of the air fryer is transferred from Harvey Norman to you as the buyer so that you can bring the air fryer home. Okay, so you will pay for the air fryer when the bill of your credit card comes to your house. Okay, or when the bill for your credit card is due, then you will have to pay, and payment happens much later than the delivery. Okay, so that is an example of possession being physically transferred. As I said earlier, that there is another type of transfer of possession, which is constructive delivery. Okay, for example, my new black Honda City 1.5e is ready to be collected. So the Honda dealer passes the car key to me. So that is constructive delivery. Okay, whether by handing over the key, the possession of the car is now transferred to me. Okay, in some cases, it could be the document of title. Okay, so I remember that last week, okay, one of your classmates asked what is exactly delivery. Okay, so I'm sure that when I mentioned delivery earlier, you were confused, okay? Because what I'm sure that what came across your mind is actually delivery to doorstep, okay? Just like how the goods you bought from Lazada or Shopee or whatever platform, okay, where the goods are delivered to your house or to your hostel. Okay, but I must say that delivery until your doorstep or your hostel or of your house is either the practice or rather one of the terms of the contract of sale, where the seller has agreed to deliver to your doorstep. Okay, doorstep delivery is not a statutory position, it's not a legal position. Okay, it not legal, is not a statutory position. It is not provided in the statute, but rather it is an agreement between the parties. Okay, why? Okay, we look at section 36. Okay, we look at section 36, which provides for rules of delivery. Okay, firstly, the general rule in subsection 1 says that goods sold are to be delivered at the place at which they are at the time of the sale, and goods agreed to be sold are to be delivered at the place at which they are at the time of the agreement to sell, or if not then in existence, at the place at which they are manufactured or produced. So, for example, a buyer goes to IKEA to buy some furniture. Okay, so according to section 31, the seller, that is IKEA, has a duty to deliver. Okay, but this duty under section 36 sub 1, under section 31, okay, because under section 31 says it is the duty of the seller to deliver the goods. Okay, but it does not mean that IKEA has the duty to send all the furniture or to send the furniture to your house. Okay, because based on section 36 sub 1, delivery is made when you take possession of the furniture at the IKEA store or IKEA warehouse, okay, or the IKEA showroom. That is the place where the furniture are at the time of the sale. Okay. Similarly, if the furniture are still under construction, that means there is an agreement to sell, then the delivery can happen in the showroom or in the factory, okay, as long as it is the place where they are produced. Okay, but of course, in practice, okay, for the reason of the competition between the business entities, a seller would voluntarily undertake not voluntarily undertake, but offer. Okay, a seller would offer to send the goods purchased to the doorstep of the buyer, okay, with a certain charge or free of charge. Okay, that is apparently the norm today. Okay, and that norm could actually be interpreted to be an agreement between the seller and the buyer. Okay, then this norm or this agreement between the seller and buyer is covered by the earlier part of section 36 sub 1, which says that whether it is for the buyer to take possession of the goods or for the seller to send them to the buyer is a question depending in each case on the contract expressed or implied between the parties. Okay, so if the goods are already there, okay, then it is for you to pick it up and bring it home. Okay, that is the statutory position. But if you and the seller agree that the goods, the seller should send the goods to your house, then that is by agreement between the parties. Okay, otherwise the general rule is goods sold are to be delivered at the place at which they are at the time of the sale, and goods agreed to be sold are to be delivered at the place at which they are at the time of the agreement to sell, or if not then in existence, at the place at which they are manufactured or produced. Okay? And this proposition is supported by section 33 when it says delivery of goods sold may be made by doing anything which the parties agree shall be treated as delivery. Okay? So as long as the seller and the buyer agree with a particular arrangement which shall be treated as delivery, a delivery will happen accordingly. Okay? So for example, if the seller and the buyer agrees that the seller should put the things on the bridge, on a particular bridge, then that would be deemed as delivery as agreed by the parties. Okay? So apart from that, section 33 also says that delivery of goods sold may be made by doing anything which has the effect of putting the goods in possession of the buyer or of any person authorized to hold them on his behalf. Okay, so this may cover the situation where it is not the buyer himself, okay, that would accept delivery. Rather, the goods are to be sent to perhaps his agent, or just by leaving it at the warehouse, and the buyer would come and collect them. Okay, and even though section 35 says that the seller of goods is not bound to deliver them until the buyer applies for delivery, but like I said just now, it has become a norm today that the seller will offer delivery or to send the goods to you, okay, due to the competition in business. Okay, so the general rule remains that the buyer cannot assume that the seller will automatically deliver the goods unless there is any express contract to that effect. Okay, and that also explains why now when you buy things, you buy goods from these online platforms, the goods are always being sent to your house. Okay, because that is part of the agreement, okay, between you and the seller through the platform. Okay, but the general rule is that we as the buyer shall not expect or shall not assume that it is our right that the seller should send the goods to us. Okay? Like I said, it is because of the competition that now the seller offers to send it to us. Okay, of course, usually with charges. Okay? Then another important provision here is section 36 sub 3. Okay? When goods, where it says that when goods at the time of sale are in the possession of a third party, for example, a warehouseman, there is no delivery, okay, by the seller to the buyer unless and until the third person or the third party acknowledges to the buyer that the goods are held on behalf of the buyer. And this is subject to its proviso that says nothing shall affect the operation of the issue or transfer of any document of title to goods. Okay, so for example, I want to buy a spare part for my car. So I go to seller X. He asks me to pay, then get a spare part from another warehouse which X has collaboration or cooperation. Okay, so let's call that warehouse as Y. So here, Y is the third party. Okay, the spare part cannot be considered to have been delivered unless and until Y tells me that he is holding the spare part on my behalf. Okay, otherwise, in a normal circumstance, when I make payment to a seller, the seller concurrently passes the goods to me. But under section 33 sub 3 is a bit different because the goods are with a third party, and in our case here it's Y. So in such a situation, usually X would issue a bill of lading or any document, okay, of this nature to me, and X will sign this bill of lading, and I will also sign, and then when I go to Y will also sign. So this bill operates as an acknowledgement. Okay. So when X passes the bill of lading to me, that already constitutes delivery of goods. Okay, a constructive delivery. So I don't have to have an acknowledgement from Y. Okay, that is the effect of the proviso. Okay, and then so that is about the general rule about delivery. And now we come to place of delivery. Okay, the relevant one would be section 36 sub 1. Okay, the place of delivery could be where the goods are at the time of sale, where the goods are at the time of the agreement to sell, or where the goods are manufactured or produced. Okay, but of course, as I said earlier, the parties may agree otherwise. So if the buyer wishes the goods to be sent to somewhere else, that has to be agreed with the seller. Otherwise, the duty of the seller to deliver is limited to making it available for the buyer to collect. Okay. So the duty is limited to the fact where the where the seller would get the goods from the store and then put it in the showroom or to the sales room for you to get the goods. Then that is considered delivered. Okay. So in the case of Gilbreth and Grant Limited, the court said that if a seller was bound to deliver goods to the buyer, the seller's obligation was completed if the goods were delivered at the buyer's premises to anyone with apparent authority to receive them, as long as the seller had not been negligent. Okay, so under section 36 subsection 5, while it is the duty of the seller to deliver, it is also the duty of the seller to prepare the goods into a deliverable state. Okay, any expenses for that purpose should be borne by the seller. Okay, for example, the seller of logs, balak, kayu balak, should have chopped down the trees and gathered the logs at a particular point to make the logs in a deliverable state. Okay, so that when the buyer can come and collect the logs by their trucks easily. So if the trees are not yet chopped or the logs are scattered all over the forest, and the seller says it would cost him a lot to gather the logs at an assembly point, he asks the buyer to pay for that cost. That would be a breach of section 36 sub 5. Okay, that would be a breach. But as usual, that is just a general rule because section 36 sub 5 starts with unless otherwise agreed. So the parties may agree otherwise. As long as they have agreed, then the buyer may need to drag the logs down from the forest or to pay for the costs for dragging the logs down, okay, to the seller. Okay, he would have to pay, the buyer would have to pay the cost to the seller. Okay, but if not, then it is the duty of the seller to deliver and to put it in a deliverable state and to deliver the goods. Yeah. Then time of delivery. So we already know that it is the duty of the seller to deliver the goods. Then the delivery generally happens, okay, at the place where the goods are at the time of sale. Nevertheless, the parties may agree for the seller to send the goods. Okay, for that purpose, parties will usually fix a time, okay, for the seller to send the goods. But if there is no agreement as to the time of delivery, Section 36 sub 2 requires the seller to send the goods within a reasonable time. Okay? And if the buyer requests for delivery, Section 36 sub 4 says that that must be made at a reasonable hour. Otherwise, the request is ineffectual. And what amounts to reasonable hour depends on the fact of each case. Okay? So in some cases, when the seller who is bound to send the goods has sent the goods, and the seller requires the buyer to accept the delivery. Okay? However, the buyer does not respond within a reasonable time after the seller makes such request. In this situation, Section 44 says that the buyer shall bear any loss caused by his neglect or refusal to take delivery. If the seller has taken care of the goods due to the buyer's neglect or refusal to take delivery, then the seller is also entitled to some charges. Or even if the neglect or refusal of the buyer to take delivery amounts to repudiation of contract, the seller may still ask for compensation, okay, for the loss and charges for taking care of the goods. Okay, that is the effect of the proviso when it says that nothing in this section shall affect the rights of the seller where the neglect or refusal of the buyer to take delivery amounts to a repudiation of the contract. Okay, so there are two remedies available for the seller. And what happened? Okay, what happened if there is a mistake as to the quantity, or there is a wrong good, or there is a mixture of goods, okay, being delivered to the seller, to the buyer. If the seller sends less than the agreed quantity, the buyer may reject the goods. Okay, but if the buyer accepts them, then the buyer shall pay for the goods that he accepted, okay, according to the price. Okay, this is what Section 37 sub 1 says. Okay, an example can be seen from the case of Harland and Wolff. Here there was a contract for 500 loads of timber. However, only 470 loads were delivered. The court said that there was a non-performance, okay, amounting to a breach of condition. So according to Section 37 sub 1, the buyer was entitled to reject it. Okay, because it is logical and sensible that a buyer shall deliver the goods purchased by the buyer according to the agreed quantity. So if the seller sends more than the agreed quantity, under Section 37(2), the buyer has three options. The buyer may accept the agreed quantity and reject the extra one. The buyer may reject the entire delivery, or the buyer may accept the entire delivery. And of course, he needs to pay for the extra ones. Okay? And these are the rights of the buyer. The seller cannot insist the buyer to choose a particular option. If the seller mixes the goods purchased by the buyer with some other goods, then the buyer may accept the contracted goods and reject the rest, or he can just reject the entire delivery. Okay, and what happens if or whether he can accept the goods not under contract? There is no mention in Section 37 for Section 37(3), but for me, I don't see any problem if the buyer agrees to accept those goods and pay for them. Okay? And then Section 37(4) says that all subsections under Section 37 are subject to any usage or trade special agreement or course of dealing between the parties. Okay, trade usage, as we have looked at earlier, it has to be notorious, certain, and reasonable. Okay, whereas cost of dealing here refers to regular trading between the parties over a period of time on the basis of consistent terms of trade, which is sufficient for the same terms to be treated as incorporated in a new contract between those persons. Okay, so an example can be seen from the case of Ganda Edible Oils, Sdn Bhd. So here was a contract of sale of palm oil, yeah, for 500 metric tons. However, the seller only shipped about 480 metric tons. The shipment was done on the 29th of March. But it was until 13th of April that the seller rejected the shipment. Okay, the court agreed that there was a breach of contract. But through the documents adduced as evidence, the court said that by the conduct of the buyer, the right to reject may have been lost by waiver or by acceptance. Okay, because there was implied acceptance of the tender and or waiver of their right to reject the tender after such unreasonable and inordinate delay. Okay. Then, whether delivery can be made in installments. The general rule is that goods must be delivered all at once, but not by installments. Okay. However, as stated at the opening of section 38 sub 1, the parties may agree to deliver the goods in bits and pieces. Okay, they mean to say in the installments. Otherwise, the seller must deliver contracted quantity at once and at the same time. Okay. Section 38 sub 2 says that where there is a contract for the sale of goods to be delivered by stated installments, which are to be separately paid for, and the seller makes no delivery or defective delivery in respect of one or more installments, or the buyer neglects or refuses to take delivery of or pay for one or more installments, it is the question in each case, depending on the terms of the contract and the circumstances of the case, whether the breach of contract is a repudiation of the whole contract or whether it is a severable breach giving rise to a claim for compensation but not to a right to treat the whole contract as repudiated. Okay, so this is stated in 38.2. So what does this mean? First, there must be a contract stipulating that the delivery of goods should be done by installments and payment should also be made by installments corresponding to the delivery. Okay, so I will give you an example later. So this is the first one. Secondly, the seller fails to deliver or the delivery is defective, or the buyer neglects or refuses to take delivery or pay for any of the installments. And thirdly, it is to determine whether the contract is severable or indivisible. If it is an indivisible contract, the breach of contract would be regarded as repudiating the whole contract. But if it is severable, the breach of contract entitles the innocent party compensation, but the contract must go on as it is still valid. Okay, and whether it is a severable or indivisible contract, that depends on the terms of a contract as well as the circumstances of the case. Okay, so there are these three conditions here. So I give you an example. Yeah, the parties contracted for the sale of 100 tons of cotton, and they agreed that the cotton should be delivered in 20 installments of 5 tons each. Okay, 20 installments, 5 tons each. Okay, so a breach meant by this section could be the seller failed to deliver any of the 20 installments, or the seller delivered less than 5 tons for a particular installment, or the buyer, due to its own negligence, failed to prepare the warehouse to properly store the cotton. And because of this, he refused to take delivery of cotton. Or the buyer did not pay for any of the installment. Okay, so when any of this happen, the court will need to look at the contract and conduct of the parties to determine if the contract between these parties is a severable or indivisible contract. Okay, so that the rights and liabilities of the parties may be properly determined. Okay. Okay, so that would be about delivery, and that is the essential or the main obligation of the seller. And now we come to the obligations of the buyer. Okay, that is to accept the goods. And acceptance is important from legal perspective. Of course, as a buyer, it is important that you receive the goods. Okay, but at the same time, the receipt or the acceptance also has some legal consequences. Okay, and this can be seen from at least two provisions. Number one is Section 31, okay, which imposes a duty on the buyer to accept and pay for the goods according to the contract. As a result, if the buyer fails to do so, it will render the buyer liable for breach of contract. That means you have to accept and pay. Secondly, when it is an inseverable contract and the buyer has accepted the goods or part of the goods, if there is any breach of condition by the seller, the buyer can only treat the breach as breach of warranty. The contract is not repudiated and still goes on. Okay, this is stated in 13 sub 2. Okay, if you could recall the example that I gave you, I think in the first class, okay, where the books sent to the library are in uneven number. Some receive 5, some receive 8, and it is an inseverable contract. Okay, and the librarian has arranged the books on the shelf, okay, for the use of the lecturers and the students. Okay, so there's an acceptance on the part of the buyer, okay, on the part of the university. So even if there is any breach of condition by the bookseller, the university can only treat the breach as breach of warranty. Okay, the contract would still go on. Okay, so that is important, because if you did not accept, then the contract, the breach of condition is a breach of condition. It cannot be treated as a breach of warranty. Okay, so that shows how important acceptance is. Okay, and how do you accept goods? Section 42 lists down 3 methods. Again, to tell you when does acceptance happen, okay, in the eyes of law. Number 1 is when the buyer intimates to the seller that he has accepted the goods. Number 2, when the goods have been delivered to the buyer and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of a reasonable time he retains the goods without intimating to the seller that he has rejected them. Okay. I think the first method is self-explanatory. To intimate means to inform. So this is the most straightforward method, where the buyer informs the seller that he has accepted the goods. Okay, and then the second method suggests that there is no intimation or acknowledgement made by the buyer to the seller that he has accepted the goods. Instead, without informing about the acceptance, the buyer does something to the goods which is inconsistent with the ownership of the seller. For example, when the buyer receives the goods, the buyer sells the goods to a third party. Okay? By selling the goods he received from the seller, the buyer can be said to have assumed ownership over the goods. Okay? So, the ownership of the seller over the goods has been parted. Okay, so this is inconsistent with the ownership of the seller. So when this happens, there is an acceptance. Okay, so for example, in the case of Hardy and Co. So here there was a contract for the sale of wheat. Okay, so after the wheat had arrived at the buyer resold some of the wheat to the sub-buyers. But after that, he found that the wheat did not conform to the contract. So he alleged that there had been a breach of condition by the seller. So he made a claim against the seller. But the court dismissed the claim on the ground that by reselling the wheat to the sub-buyers, it amounted to acceptance. So it was too late for the buyer to reject for breach of condition. Okay, so the most he can do is to claim for breach of warranty. And then in Toyo Photo Products Sdn Bhd, the seller and the buyer entered into a sale contract, okay, for a machine worth 600,000 ringgit. Okay, then the seller sent and installed the machine at the buyer's premises. Then later, the buyer claimed that the machine was not the machine contracted, and he also claimed that the machine was defective. So he refused to pay the balance price of about 180,000 ringgit. So the seller sued for the balance sum, while the buyer counterclaimed for, among others, the return of the purchase price that he had paid. So that is about 420,000. So in this respect, the court dismissed the buyer's counterclaim as the evidence showed that although he rejected the goods, at the same time he continued using the goods. He even claimed for the rental for the period during which the machine was placed at his premises. So the court said that the buyer was in fact having the best of both worlds. Okay. And in Mukan Limited and Malaysia Steelworks Sdn Bhd, the Court of Appeal stated that acceptance by usage was the most compelling evidence of acceptance. Failure to reject the goods within the warranty affirmed that acceptance. So that is obviously what happened in Toyo Photo Products, where the buyer rejected the goods, but he did not tell the seller. In fact, he continued using the goods. Okay. And then the third would be when after the lapse of a reasonable time, he retains the good without intimating to the seller that he has rejected them. Okay, this means that the buyer has received the goods. However, after a reasonable time, he does not inform the seller that he accepts the goods, nor does he do anything inconsistent with the ownership of the seller. Most importantly, he does not tell the seller that he rejects the goods, and at the same time, he keeps the goods. Okay, as such, he is presumed to have accepted the goods. Okay, so based on what the court said in Fisher, Reeves and Co. Limited, it indicates that the buyer has time, okay, to consider whether to accept or not. Okay, if he does not do so, that does not mean that he has waived his right to reject. However, if he does not reject within reasonable time, he must be taken to have accepted the delivery. So that means you cannot say that simply because the buyer fails to reject, there is an acceptance. That is only when he fails to inform or to intimate to the seller that he has rejected them after the lapse of a reasonable time. Okay, then only you can say that he had accepted the goods. Okay, and what amounts to a reasonable time depends on the facts of the case. So when there is a period specified in the contract, then that must be given effect. Okay. Okay, so now we come to the remedies. So what are the remedies available? Well, parties have rights and obligations under the contract of sale. There are remedies, okay, available when either of them breaches the obligation. So, in essence, when the breach is committed by the buyer, there are remedies available to the seller. Okay, for example, the seller may take action for the price of the goods sold when the buyer refuses or neglects to pay for the goods, or when it is a duty of the buyer to accept the goods, he fails to do so. Okay. Similarly, the law also gives protection to the buyer against the breach committed by the seller. For example, the goods delivered are defective. Okay, the goods delivered are not up to the quality or quantity as promised, or there is a late delivery, or there is even non-delivery by the seller. Okay, so there are remedies that the innocent party may ask for in case of breach committed by the opposite side. So for the purpose of this part, we will look at it from two different perspectives. One is the remedies for the seller. That means, what can the seller do when there is a breach committed by the buyer? And secondly, the remedies for the buyer. That is, what can the buyer do when the seller commits a breach? So we will start with remedies for the seller. The remedies for breach by the buyer, okay, the remedies for the seller or the remedies for breach by the buyer may arise from any of the following act. Number one, failure of buyer to take delivery. Number two, failure of buyer to accept goods. And number three, failure of buyer to pay for goods. Okay, so as we have seen earlier, Section 31 imposes duties respectively on the seller to deliver the goods and the buyer to accept and pay for the goods. Okay, but Section 44 says that when the seller is ready and willing to deliver the goods and requests the buyer to take delivery, but the buyer does not take delivery of the goods within a reasonable time, then the buyer is liable to damages and reasonable charges. Okay, so the buyer is liable to pay compensation to the seller for the loss the seller suffers as a result of the buyer's failure to take delivery. The buyer is also liable to pay charges to the seller if, due to the failure of the buyer to take delivery, the seller has to look after the goods. Okay, and there is a proviso to Section 44. Okay, and the proviso provides another layer of protection to the seller. This means that even if the contract is repudiated due to the neglect or refusal of the buyer to take delivery, the seller may still ask for compensation for the loss and charges for taking care of the goods. Okay. Then the second is caused by the failure of buyer to accept goods. Okay, Section 56 is the relevant provision, which says that where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may sue him for damages for non-acceptance. Okay, as you can see, I've listed some cases. Okay, and for example, in Architect Tenggara Sdn Bhd, where the federal court, yeah, stated that the general principle for the assessment of damages is compensatory. Okay? That is, the innocent party is to be placed, as far as money can do, the same position as if the contract had been performed. Okay? So, to be entitled to damages, the seller under Section 56 has to prove that it is the buyer's breach. Okay? That is the failure to accept and pay for the goods, which causes loss to the seller. Okay? And the court in the case of Teo Kee Keong stated that the general measure of damages under Section 56 is covered by Section 74 sub 1 of the Contracts Act. Okay? That is, damages which naturally arose in the usual course of things from the breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Okay? So this is under Section 56. And the only condition of Section 56 is that the buyer's failure to accept and pay for the goods. Okay? So it concerns both both non-acceptance and non-payment. Okay? The buyer did not accept and did not pay for the goods. Okay? So this section is usually relied on when the wrongful non-acceptance happens. Okay, because it is natural for the buyer to reject delivery and therefore refuse to pay for the goods. Okay, it is quite illogical to say that the buyer is willing to pay but not willing to take delivery of or to accept the good. Okay,